politics, long-haired weirdos, short-haired weirdos, vandals, hooligans.
The government, hug the government, love the government, hug the government, love the government.
Welcome to The Politics Guys, a place for bipartisan, rational, and civil debate on American politics and policy. I'm Trey Orndorff, a political scientist at Oklahoma Christian University, and I'm joined by Ken Katkin, a professor of law at Chase Law School. Welcome to The Politics Guys, Ken.
Thanks, Trey. It's great to be back.
It's always fun doing the show with you, and we're going to start this week on the story Bolstock versus Clayton County. But before we do that, we have this message. So, Ken, this week the court took up Bolstock v. Clayton County, the Supreme Court did, and what it's really centering on is the 1964 Act, Civil Rights Act passed by Congress. And the 1964 Civil Rights Act is designed, it was groundbreaking because it was designed to prevent discrimination in hiring of private employment decisions. I think one of the things that a lot of citizens, a lot of listeners might not recognize is when you think about a lot of your civil liberties and your civil rights, those are actually protections that are coming in terms of governmental interference. And what was kind of groundbreaking in many ways about the 1964 Civil Rights Act was that it was extending, if you will, those protections to the private sphere, in this case, into employment decisions. And so this included, really importantly for the time, both race and sex. You couldn't be denied employment on the basis of whether you're a man or a woman, or on the basis of your race. And I think that a lot of people this week have been really kind of rightfully, I'm going to say, as kind of my libertarian leaning direction suggests, applauding it because it ends a form of discrimination. Yet there is still a question about this, because what happens to make this work is that the Supreme Court really had to kind of evolve its understanding of the term sex in Title VII of the Civil Rights Act. So at the time Congress was passing the act, it is clearly not likely that sex was intended to include gender identity or sexual orientation. But the court majority argued, Ken, that, quote, the straightforward application of Title VII's terms interpreted in accordance with their ordinary public meaning at the time of their enactment resolves these cases, end quote. The minority disagreed. They state, quote, there is only one word for what the court has done today: legislation. The document that the court releases in the form of a judicial opinion interpreting a statute, but that is deceptive, end quote. They go on to note that neither sexual orientation nor gender identity appears on that list, and that for 45 years, Congress has introduced legislation to add sexual orientation, meaning that Congress clearly did not see Title VII as including it originally, and yet have continued to fail. So I want to start in terms of the law here. What do you think, Ken? Is this court trying to do what it seems to be morally good regardless of the law? Are they kind of filling in for the deficiencies of Congress? Or do you think this is the right ruling just on legal grounds?
Well, there's so many things I could say about this case. I think it's the right ruling on legal grounds, but not at all on the same legal grounds that the court decided in the Gorsuch opinion. I don't agree with the Gorsuch opinion. So
you disagree with the majority opinion, but you agree with the outcome. So you'd be a concurrence, effectively.
Yes, I would have. And I've got to say, I believe that the 4 Democratic justices who joined the Gorsuch opinion, none of them wrote any concurrences. But I don't believe any of them agreed with the methodology and the opinion. But I think they just thought it was more important to have a 6-justice majority opinion,
as opposed to a split decision.
As opposed to split decision, yeah. That they went along with it. But it seems to me like a pretty it's a form of conservative judicial activism of the type that I really do not appreciate. And methodologically, that is, although in this case it reaches, I think, a liberal result that I would have rather seen reach through more liberal constitutional interpretive methods.
So what would have been, I want to start there then, what would have been your argument for, and again, kind of the crux of the legality here is, Congress passes the law that refers to sex, has not been able to pass a law that includes either gender identity or sexual orientation. So what would be the proper mechanism for understanding how that statute applies to. Why don't we just start with sexual orientation?
Right. Do you mind if I give a somewhat longish answer to that question?
Sure, go ahead. And if I get bored,
Okay.
I'll just say so, and then I'll interrupt you.
Yeah. Okay. Yeah. I usually try to keep it terse, but I want to explain a little more about what I don't like about the Gorsuch opinion and why I called it conservative judicial activism before I get to what I think would have been a better way to do it. So, I think the textualist method that Justice Scalia really pioneered, along with some other judges of the 1980s, like Judge Frank Easterbrook of the Seventh Circuit, Judge Bork to some extent. That method, I think, is a method of conservative judicial activism that was crafted with a very result-oriented purpose. The idea was that the Congresses from the 1930s up to the 1970s and 80s were mostly run by liberal Democrats. And most of the legislation that was enacted from the 1930s to the 1980s was liberal Democratic legislation, and the people who drafted it understood what they meant by it. Now, I think when the textualists came in during the Reagan administration in the 80s, and that became a big judicial movement, the very purpose of textualism was to sever text, reading plain language of text, from trying to understand what Congress actually meant, for the purpose of interpreting statutes in ways that are different than what Congress actually meant. I think that's literally what textualism was about, and I think it's a despicable methodology. Now, I think
can I ask you a question about that before you keep going forward?
Yeah.
Because one of the things that that has long been kind of a bugaboo on the left was kind of the idea that you should understand, say, the Constitution in terms of an original intent, and that is in fact the method that one ought to use for congressional actions as well. And that was often met with resistance historically from the left. But it seems like in this case, you would be more sympathetic to an originalist. Am I understanding that correct?
No, I'm not for originalism or textualism. I don't like either of those methods, but I think they have different problems, right? Textualism is very anti-originalist, but it has this different problem that I think the purpose of textualism is to interpret statutes the way they weren't intended, right? So it's a method that's very much saying we don't care about congressional intent. We don't care what the Congress actually meant. We only care about the literal meaning of the words that they used. And if that's different than what they intended, we need to go with what they said, not with what they meant. And I do believe that was crafted for the purpose of nullifying a lot of the work that Congress did from the 30s to the 80s. And I believe that what Gorsuch did in the majority opinion is just a textbook example of that. Because I think, of course, you're right that the Congress in 1964 wasn't thinking about sexual orientation discrimination. They did use language that, if you read it very literally and rip it from context, does discriminate based on sex. They prohibit discrimination based on sex. So if an employer takes an adverse action against somebody because that employee is male and is dating other males, but they wouldn't take an adverse employment action against a female who was dating males, well, then quite literally they have discriminated based on sex. So if you sever the literal meaning of the language from the actual intent or understanding of the Congress that enacted it, which is what I claim textualism always does, then Gorsuch is doing textualism in the ordinary conservative activist way, and he's giving a correct interpretation of the literal language of the text, which, because he's not looking at what they actually meant. And that's what textualism does. Now, I think originalism, which is really to some extent what the Kavanaugh opinion here argues for, Kavanaugh tried to argue that we should try to understand
the intent of Congress.
The intent of Congress, right? Not what the words mean literally, but what the Congress that enacted them intended them to mean. And that's not a textualist approach, right? If you're gonna privilege what they meant rather than what they said, then that's an intention. We'd probably call that an intentionalist approach, but you could call it an originalist approach. But I don't really like that so much either. What I think what liberal interpreters tend to like best are forms of interpretation that are sometimes called dynamic statutory interpretation, or they're sometimes called ethical statutory interpretation, that Justice Oliver Wendell Holmes 100 years ago called the living Constitution. And you can apply that to statutes as well, where you think about what are the broad principles that were intended by these legal texts, and how do we apply those first principles to contemporary applications. And so I think if you think about the first principles in the Civil Rights Act of 1964 as being about making it impermissible for employers to discriminate in employment decisions in ways that we would consider to be prejudice or bias or animus or just improper bases, then we could say we had some evolution in understanding about whether that first principle applies to discrimination based on sexual orientation. But that the first principle that they enacted in 1964, they may not have thought that would apply to sexual orientation discrimination. But we now understand today that sexual orientation discrimination isn't that different than race discrimination or sex discrimination or other kinds of discrimination. And so applying that first principle to our contemporary understandings and to this contemporary application, I think that's a bona fide, what I would consider a bona fide liberal form of interpretation.
Well, can I ask you though, on that? Because what you've decried, and you've done this on the show a number of times, and I don't think we've ever had a chance to kind of push on it, was what you call, and you've said it here again, kind of conservative activism. Right, that they're using this to achieve a specific kind of outcome. But of course, what you've just described there is also a form of activism in the sense that you have to interpret the intent of Congress as principle for what they've done, and then apply that principle into a situation in which the Congress clearly would not have made an. I mean, you're effectively creating legislation from a principle that you think is embedded in a piece of legislation that does not contain that actual particular outcome. I mean, isn't that just a different kind of activism?
Yeah, I accept the allegation. I think it is. So I think it's inevitable, right? Now you could do the kind of thing that Kavanaugh argues for in his concurrence and say that what we're really trying to figure out is what did that Congress at that time mean? What kind of specific meaning did they mean? What was their specific understanding? And I think that's the most minimalist way to look at this. That's the least activist way to look at it. But I think
you don't like that, of course. I can.
Yeah, I don't like it as much. I mean, I don't dislike it as much as I dislike what the methodology that Gorsuch used.
Okay.
Because I think that the methodology that Gorsuch used is really to purposely and perversely try to interpret statutes against their actual intended meaning or their actual intended understanding. And I think that's kind of the hallmark of conservative judicial activism. Now, I will own the idea that what I'm advocating is liberal judicial activism. I'm not going to deny it, right? But what I'm saying is that I think it's a better, it serves society better for courts to try to figure out what are the principles, what are the best versions of principles that Congress actually enacted, and how would we apply that to contemporary situations? If I give one example, if you think about Brown versus Board of Education, which is a case that most people like nowadays, right? The case that desegregated schools, that's based on the idea that the equal protection principle in the Constitution means that the government can't classify people based on their race and generally can't treat minorities worse than white people because of their race or differently from white people because of their race. But yet we know that at the time of the ratification of the 14th Amendment, there were plenty of segregated schools in the country, and the people that ratified the 14th Amendment didn't think that changed because the 14th Amendment was ratified. It didn't change during the whole 19th century or early 20th century. But what I would say is that Brown is a correct decision despite that, because even if the framers and ratifiers didn't specifically intend the 14th Amendment or understand the 14th Amendment to desegregate public schools, I think they laid down a principle of equality that, rightly understood, does require desegregation of public schools. So I think that's an example of what I'm talking about. I think that's a correct kind of interpretation, but I'll own the fact that it's an activist form of interpretation.
What about the critic who's going to argue then, and this is kind of a common one, is to say, well, look, once you've kind of owned, you have the liberal conservative activist, the liberal and the conservative activist, this ceases to be about law and just becomes all about outcomes, right? So you're going to want to be, if you think that conservative principles are more important, you're going to end up taking a conservative activist point of view. And if you think that these liberal principles are more important, you're going to take a form of understanding the law that allows for a liberal activist to move forward. And really, therefore, it's not about the law at all. but really just it's kind of a post facto legislative battle in an unelected body.
Yeah, okay, I get that complaint, but the reason I don't agree with it is one, I think that the two types of activism I described, I don't think they're as symmetric as how you described them.
Okay.
Because I think the conservative activism, particularly through textualism, is literally about trying to interpret statutes against what the legislature actually intended. Whereas I think the liberal kind of activism is trying to figure out the core principles that the legislature actually intended and apply them in ways that are modernized. So I think the liberal activism is more sympathetic to what the original legislatures were trying to accomplish, whereas the conservative activism is really working against what the original legislatures were trying to accomplish. And so I think they're different. But the other thing I would say about this, particularly in statutory interpretation, is that very frequently, and I do think the Bolstock case is a good example of this, because there's so many anti-democratic roadblocks built into our legislative process that you're often going to see situations, and I think this is one of them, where strong popular opinion, it's not that close, actually favors the result that was reached in the Bolstock case, but yet there are impediments because of things like the filibuster rule in the Senate for Congress being able to keep up with public opinion. And so because of that, when the court updates something like this, and I would again accept that it's activist and it's an update of a law. I think what they're really doing is keeping the law in step with society in ways that are actually more democratic than some of the processes that are available in the legislature. And the legislature, of course, if they had the votes to overrule a decision like this, they could. It's a statutory decision. So if the court really gets way out ahead of Congress, then Congress can just overrule the court in a statutory case. It's a little bit different that way than in a constitutional case. But here, I don't think the court did get way out ahead of popular opinion. I think they actually caught up with popular opinion.
Well, now that's interesting. This kind of gets to the second part of what I wanted to ask you about, and leading to how you'd argue eventually, and that is that if we take that view, effectively, the court becomes the fixer of the inherent institutional issues of Congress, which it kind of begs the question: Congress gets a lot of flack leveled at it. I think a lot of times on this show that we probably take a pretty positive view of Congress compared to the popular view. But this would then kind of indicate, well, look, Congress can't get done what it's supposed to do. And so the courts are going to have to step in some way and be activists. We'll just use that loosely defined at the moment. Otherwise, there will become a disconnect between what people want and what Congress is willing to do. But if that's ultimately true in a major way all the time, isn't that a critique of our primary democratic institution? And wouldn't that suggest there's a fundamental problem with Congress? In other words, if you have to think about the court as a fixer of the problems of Congress, isn't that fundamentally a problem with Congress?
Yeah, I think it is, but I don't think it's all the time, right? So I think cases like the Bolstock case, you have them every year, but not that many of them. So I think the overwhelming majority of the legislating is being done well by Congress and actually also by administrative agencies. So there's the third branch here,
which
also,
we're going to get to in a second story, as a matter of fact.
Yeah. So really, all three branches have a role in constructing the law, but I think it's an appropriate judicial role to try to keep principles that Congress has already enacted updated to apply to contemporary applications. And I really would only draw the line when what the court's doing is really trying to go against the principles that Congress already enacted. And I don't see that in the Bolstock case, but I do see that in a lot of textualist cases. So I think that's kind of that. I think if there's a partnership in constructing the laws that goes between all three branches, including the executive branch, which promulgates a lot of regulations, that I think that's part of the judicial role, is to update interpretation of existing statutes in ways that are faithful to the core meanings of those existing statutes, but that apply them to new applications.
Yeah, see, I think where you're going to find some more flack on that front, as you get away from thinking about it in just purely judicial interpretation terms, is that individuals are going to say, well, yeah, that's your particular principles that you're reading into it, not necessarily, their, as you put it, kind of their best version of it. But it sounds like then, though, that your word, I mean, like, look, the purpose of this did not encompass sexual identity, for example, but that's the clear underlying principle, and therefore today we need to rule in this way to apply Title VII to these circumstances in 2020. Am I giving you a good read there? Is that?
Yeah, that's what I truly believe, and that's what I think. Probably the 4 Democratic justices on the court also truly believe, but they didn't write an opinion like that because I think they didn't want to shatter the majority. There was a 6-justice majority for an outcome that they wanted, and they were willing to go along with Gorsuch's really aggressive textualist approach, where by everybody's understanding, I think he's interpreting the text to be contrary to the actual understanding and meaning of the Congress that enacted it. But I think that's what textualism is all about.
So now I want to ask you just kind of a quick question before we move on to our next story about this, though, because you're interpreting the idea here that they don't write so as to have the majority. But there's also an argument to be made that it appears that some of the liberals are, in fact, kinds of textualists. Aren't we all textualists now, as I understand?
Yeah, that's been said. And I think, Breyer has said that and Kagan has said that. But I think they just have to, use the methods that can get a majority on the court sometimes. But I think textualism would recede in the court if there weren't 5 Republican justices. I think it's Democrats can use it. And actually, like, one of the great textualists and one of the great originalists before Scalia even was Justice William Brennan, who was one of the most liberal justices that ever sat on the court. And he was really the founder of originalism. And he tended to use originalism to reach very liberal results. So these tools can be deployed by either side, and I think for the minority side on the court, they pretty much have to be willing to wield the tools that the majority says are the legitimate tools. But that's sort of all I think about that.
Well, why don't we turn to another case, the DACA case? But before that, we got a quick break. Okay, so Ken, we just got done chatting about Title VII and the Civil Rights Act, and a lot of conversation about interpretation. And I don't think we're going to veer too far,
Right.
Because on Thursday, the United States Supreme Court blocked the Trump administration from ending the Deferred Action for Childhood Arrivals program, commonly known as DACA. And so, just for a little bit of background here. DACA comes from a memorandum from the Department of Homeland Security during the Obama administration. And in it, it allowed unauthorized aliens who arrived in the U.S. As children potentially to apply for 2-year forbearance from removal. And further, it granted the ability of them to have work authorizations and other various federal benefits. Now, what happens is that the Trump administration decided it was time to end DACA. And so they did so. Now, the plaintiffs in the case have argued that the way that DACA was ended violated the Administrative Procedures Act, APA, and it also violated the Due Process Clause. And that the reasoning for ending DACA was that government was arguing it was illegal. And this is where I think it kind of gets into the fascinating policy weeds, because the Trump administration is not rescinding it so much as they're rescinding it on the grounds that DACA in the first instance was in fact illegal when the Obama administration, through Homeland Security, issued it. And so because of that, it is a potential, quote, violation of the APA, according to Chief Justice John Roberts. Effectively, what he's saying is the Trump administration has the power to rescind policy, but that in this particular case, it's, quote, arbitrary and capricious, end quote. And that arbitrary and capricious manner is what makes it violate the APA. So in other words, it is the court has blocked this largely because of what you might call administrative bungling. Because the program was enacted by President Obama and not by legislation, it means that future presidents, of course, could undo it. So, Ken, I know a lot of people are celebrating the decision right now, but my reading of the court's decision is that Trump could still very easily and will end DACA. As a matter of fact, on Friday, he even mentioned in Twitter that that's what they're going to be doing shortly. So take us a little bit into the contours of this case and maybe make a prediction on whether you think a revised ending of DACA might happen, meeting the outline of the majority opinion. And why do you think the Trump administration took this particular legal route in the first place? You talked about this earlier in the show. Why not just make it a policy move? Why push for the illegality?
Yeah, so there's a lot of great questions there. So, and actually, the last question you asked about why, I've been researching all day, so I can't wait to start talking about it. The decision, when Obama adopted DACA, DACA is not part of the immigration statutes. So the main way that Obama did adopt it was by the president's inherent authority to set enforcement priorities. And the idea would be, there's 10 to 12 million people in the United States who are deportable aliens. And there's not enough staff in the immigration authorities to deport 10 to 12 million people all at once. So they have to set priorities. And so within that framework,
first? Yeah.
Who goes first? Yeah. So President Obama, by executive order, said essentially the Dreamers, children who are brought here as children and who've never gotten in any trouble while they were here, will be the lowest enforcement priority. So you've got to deport the other 10 or 11 million people first before you get around to trying to deport the DACA recipients. So that was what the Obama order said. So it's really a prioritization of enforcement resources.
And I think it's a big deal because I think a lot of people think that DACA is a citizenship when it's not.
It's not. It's just an executive order saying that although the Dreamers are in fact undocumented aliens who don't even have a path to citizenship and who are deportable, it's just that deporting them will be the very lowest enforcement priority of immigration authorities. So that's all that the DACA order ever said. And certainly if Congress passes statutes that make 12 million people deportable and doesn't pass statutes that provide enough enforcement resources to actually deport 12 million people, then it's inherent that there's going to have to be some executive prioritization of enforcement resources. So I think the DACA order, under kind of standard administrative law principles, was fairly clearly legal. It would be sort of impossible not to set some enforcement priorities. Now, there had been a case in Texas during the Obama administration where a federal district judge found that it was illegal, but that ended up getting reversed at the Fifth Circuit Court of Appeals. So there's some reasonable basis to think that the order was legal. But on the other hand, because it was President Obama's enforcement priorities, certainly President Trump doesn't have to have the same enforcement priorities. And if he would have just said, I'm changing the enforcement priorities, he would have won the case 9-0. But I think that I've found two reasons why he might not have done it that way.
And I think this is kind of the heart, like why the illegality? So there's two. Okay, yeah. Continue.
Yeah. So I think one reason, which seemed possible for a long time, is that Trump had politically committed himself to the idea that what Obama did was illegal. That was his political rhetoric in the 2016 campaign. That had been actually consistent with political rhetoric from a lot of other Republicans as well. That President Obama had exceeded his statutory authority by implementing DACA. That it was just an illegal act, and that therefore the president could stop the executive branch from continuing to engage in illegality without having to give any more reason than that for the change. Just say what we were doing was illegal. Now we're going to comply with the law. So I think that part of the reason that Trump did that was it was a direct reflection of the political rhetoric that I think he'd been engaging in all along. But the other reason that I think is turning out to possibly also be true and is less visible has to do with who was the acting Secretary of Homeland Security at the time and what was she willing to sign her name to. So it was a woman named Elaine Duke. She was a Trump appointee. she had been appointed as Deputy Secretary of the Department of Homeland Security because General Kelly had been appointed by Trump and confirmed by the Senate as Secretary of Homeland Security. So when Kelly was then called to the White House to become Trump's chief of staff, then that meant that the Deputy Secretary of Homeland Security became the acting Secretary of Homeland Security. So formally in administrative law, it's the head of the relevant administrative agency that has to sign off on the executive orders. It's not the president that does that. So it was really up to Elaine Duke. She was told by President Trump, we're rescinding DACA and you have to sign an order rescinding DACA. And some of the reporting that I was reading in the New York Times and the Washington Post and other places is saying that she was willing to do as told and issue an executive order that rescinded DACA, but she was really unwilling to put her own name to any of the rhetoric from the White House that she perceived as overly racist, right? So that the idea, because these students are all criminals and rapists and things like that, they're not such good people. We need to end DACA. That was the way people like Stephen Miller were talking in the White House and Steve Bannon. But apparently, Elaine Duke just would not sign her name to an order like that. So that when she did sign the order that came out of Homeland Security, her stated justification in the order was that DACA was illegal all along. But she didn't want to give any of the other justifications because she felt they were too racist and she didn't want to be associated with those justifications. So once she signed that order, then that committed the agency can only defend its actions on the grounds that are actually given in the order. So if
you can't use other conversation about it.
Right. So once she signed an order that said, well, we're rescinding DACA because it was illegal, the president didn't have statutory authority to implement it, we need to end it so that we stop engaging in ongoing enforcement of an illegal order. That was the only justification she wrote in the order. Some say because that's the only one that she was comfortable with, and she wasn't comfortable with the other ones. But then that restricted what they could argue in the courts as well. So I think both of those types of conjectures have been made. Some that Trump wanted to do it to align the Homeland Security order with his own rhetoric, or some that he was actually forced over a barrel into that by Elaine Duke because she wouldn't sign her name to orders that went beyond that. But that did prove to be very problematic because when it came to the Supreme Court, Chief Justice Roberts, along with the 4 Democrats, said, well, DACA actually is legal. So if you say you're rescinding it because it's illegal,
you can't do it.
It's just an incorrect legal argument. And you could rescind it on policy reasons, but then you have to actually show that you considered all aspects of the policy debate.
According to the APA.
According to the APA, right. And the Homeland Security never considered any aspects of the policy debate. Now, I think that it's not going to be super easy for Trump to quickly redo this during this term. He probably will be able to if he gets a second term. But right now he's up against the fact that he's got only 6 months left in office. And I think if you read the Roberts opinion carefully, there's some very serious questions that Roberts articulates that he says need to be addressed. And these would be questions like, what's going to happen to the U.S. citizen family members of the DACA recipients? How are they going to be impacted by deportation of their close relatives? What's going to happen to the employers that are currently employing DACA recipients? And he's saying, you need to think about this. You need to collect data about this. You need to explain why the harm that would be caused by deporting these people is outweighed by the benefits of deporting these people. And what is the benefit of deporting these people? And they would have to do a public notice and comment proceeding where the public could file comments on all that, which they would have to address. So I don't really think they can get that done in 6 months. So I don't think they can meet the standard of reasoned analysis that Chief Justice Roberts said that the agency should be held to, unless they've got at least a year or two of time to do it. And so I think that would depend on Trump getting reelected.
Now, I'm glad you kind of bring us there, because that brings us to the policy side. And I mean, one of the things is I was reading the opinion that it seemed to me and correct me if I'm wrong in this, but Robert's opinion seemed to be a little bit reminiscent of the genre of faculty member responding to a middling student paper.
Yeah. Well, I think, or not even middling. I'd say to a near failing student paper, right? I mean,
Like, this is bad. Here's what you shouldn't have done.
Yeah,
And kind of outline what a B or an A paper would have looked like. Because I felt like that, and I have read more than a few Supreme Court opinions. It seemed a little unusual to me in that tone, and I wondered if you agreed with that reading. Like, it doesn't seem as often the court takes. Again, I'm going to say that kind of genre.
well, it's unique to administrative law cases because of the Administrative Procedure Act, which does require agencies to engage in reasoned deliberation, to consider all important aspects of the problem and all important facts relative to the problem, and to avoid arbitrary, capricious decision making. So those kinds of particular requirements that apply when administrative agencies promulgate regulations on areas that are within agency discretion. It's not so uncommon for courts to grade their papers that harshly in that particular kind of case. It would be more uncommon in other kinds of cases.
Okay. Well, now on the policy note, it is when I see this as being, and again, this might be a stretch. Have you considered the possibility that the reason for putting it this way is a chance to again campaign on Supreme Court justices?
Yeah, I mean, sometimes I think the Republicans don't really realize that their best friend on the court is John Roberts, because I think he the kinds of opinions that Republicans have really criticized him for, including this one, including his opinion in the Affordable Care Act, or maybe the census case, although that's a little bit trickier, I think, is, these are issues that actually allow the Republicans to go into the next election not having done something terribly unpopular, right? And I think this is just another one of those, right? Like, he actually saved the Republicans from having to be held liable by the electorate for ending DACA, which the electorate overwhelmingly supports. And so I think he really punted this out back past the election, I think to the benefit of Republicans. But I'm not sure if that's exactly what you're asking. But that's is that
no, yeah, that is
yeah.
Because I mean, I guess this week I was a little bit, I'm just going to say, off put by those who were celebrating the decision, not because I am opposed to the decision. As a matter of fact, as listeners of the show know, I'm for more, not less immigration. But I think the view right now is that, well, DACA is now therefore safe, and this isn't going to happen, and these individuals are just, they're going to eventually be citizens. But really, all this does is it just punts the ultimate policy question: is what do we do with these who were children and are now my age, brought into the U.S. illegally, but have spent their whole lives here? As a matter of fact, there was an opinion piece in Newsweek by Marissa Molina, a really eloquent little piece, arguing that, look, it's not time to be celebrating, because what we still need is, despite the court's opinion, Congress still is going to have to act if they want to ensure stability for Dreamers. And no more stability has occurred for them. And that it appears unlikely that the Senate is going to move forward with any kind of legislation. The House has, the Senate has not. It's unlikely to do so, especially, as you note, we have 6 months until an election. I don't think it's likely they're going to want to take this up. And this kind of gets back to what we ended the last conversation about is this again the court stepping into the legislative void?
Yeah, but here they didn't step very far into it,
no.
Right? Because here they really just pushed back a decision until after the election, and they maintain the status quo right now. So, unlike in the Bolstock decision, which made a big change to the status quo, last week employers could discriminate against gay and transgender people. This week they can't. With DACA, all they do is preserve the status quo until after the election, and the status quo is that the Dreamers are not in danger of immediate deportation, but they are classified formally as deportable aliens with no path to citizenship. So that just really just says you've got another year or so, and we'll see how the election shakes out. And maybe Congress will actually create a path to citizenship or permanent residency, or maybe President Trump will get reelected and he'll actually properly rescind DACA, and they'll all be deported. But I think all they really did is punt that back to one more election, which I see as a fairly pro-democratic holding in that sense, right? That the legislature is gridlocked right now, so there's not going to be changes in the status quo until there's one more chance for the legislature to not be gridlocked.
But I mean, Democrats, and this is one of the ones that I will hold, they had an opportunity to pass legislation to deal with DACA and did not. Do you think it's likely that they're actually going to take that up? For me, it is long-standing frustrating that Congress has been unwilling to permanently settle the question of individuals brought here as children. I mean, put aside the larger, bigger question about immigration for a minute, but just the children who were here, who were here.
Well, I mean, Democrats have legislated. I mean, the House just passed another bill on that, but I think I would say that the holdup has been that the DACA bill, which is very popular with the whole public, it was really Republicans that tried to tie it to a lot of other things that were very unpalatable to Democrats, including massive funding for the wall on the Mexican border, as the cost of getting the DACA bill through. So Democrats have certainly voted again and again for a clean bill on DACA, and Republicans, I think a lot of Republicans voted for it also. So I think even the Republicans, or enough Republicans, might vote for a clean DACA bill if one could come up for a vote in the Senate. McConnell doesn't seem to want to let a clean DACA bill come up in the Senate, but if he did, I'm not sure it wouldn't pass.
Well, we've talked about this on the show too before, the inherent bias against immigrants in the United States, and especially children. But I think we're going to probably need to pause there, Ken, to move on to our next story, which is going to be another. I mean, this week has been full of big things. On Tuesday, Bolton's Inside Tell-All book, The Room Where It Happened, is set to come out. And this week, there have been leaks of the content of the book. And really, there's kind of two stories in this one story. One, of course, is the leaked content of the book and President Trump's response to that content. And then the second, which is kind of going along with our theme for this week, which is litigation, is the ongoing litigation from the Justice Department to stop the publication of the book due to allegedly including classified information. And so I want to start there with the litigation. So on Friday, there was a nearly 2-hour hearing in front of a federal judge to argue to delay or stop publication of the book on this coming Tuesday. The headlines for all these stories come from Judge Royce Lamberth, who had commented, quote, "It certainly looks difficult to me about what I can do about all those books all over the country," end quote. And so the legal issue is that the Justice Department has allegedly continued to alter what is or is not classified, and that while Bolton was trying to work with National Security Council reviewer Ellen Knight, that became impossible. Now, the problem, of course, is that Bolton has not received formal approval to publish his book, and as he has even put it himself, has, quote, walked away, end quote, from the review process. So in short, Bolton has not waited for an official letter from the administration clearing him to publish and moved forward as a result of what he saw as obstruction. As a matter of fact, the judge asked him why he didn't bring a court case when that happened. Kind of into this mix has been the looming threat from President Trump that there could also be a criminal case. He noted, quote, that there is a, quote, very strong criminal problem. If he, meaning Bolton, published the book, I will consider every conversation with me as president to be highly classified, end quote. So we are seeing both a civil and potentially a legal case, although I think that's less likely, against Bolton. So Ken, what do you think? Bolton never receives approval. Does that put him on shaky ground? And what about this process with National Security Council reviewer Ellen Knight, who keeps saying yes, now no, on the same issue? So let's start with the litigation side.
Yeah, well, there's not going to be a criminal prosecution, right? I mean, Trump always says that. I'm still waiting for Andrew McCabe to be prosecuted, and for Lisa Page, and all these people that he always says he's going to prosecute. It's always bull, and this is bull. The civil issue, it actually took, the headlines started coming out a couple days ago that Trump was going to sue to block publication of this book, and it actually took him until last night to get around to coming up with a legal theory by which he could sue to block publication of the book, and it's a pretty flimsy one. The main legal theory in the Justice Department's case is that Bolton himself signed a contract with the government where he agreed to submit books that he would publish for classification review before they get published. Now, his publisher never signed that contract. That's only Bolton that signed that contract. The publisher has the book, and they have every right to publish it, even if Bolton himself is violating his own non-disclosure agreement. And there's really no legal theory, I think, that would make that his agreements binding on the publisher. They never signed those agreements. The closest thing there is to a legal theory is that some of the stuff in the book, disclosure of it would also violate the National Security Act, not just the non-disclosure agreement, but that it's classified information that can't be published under the National Security Act. I think the problem with that theory is, again, even if it's true, it wouldn't be a basis for stopping publication of the book by the publisher. The Supreme Court has plenty of precedents on that, most famously the Pentagon Papers case from the Vietnam War era, where it's absolutely clear that even if information that's being published is classified and publication would violate the National Security Act, there can't be a prior restraint against publication. But also in this case, I think there's very good reason to believe that there's no information in the book that violates the National Security Act, because Bolton was pursuing this on two tracks. One is that he was pursuing it through the agency. And as I understand it, every civil servant in the agency who vetted the book said that it was okay to go, and that it was those decisions were ultimately overruled by political appointees. I think a guy named Ellis was the one, Michael Ellis, who himself had never actually even taken training in the classification rules under the National Security Act. So he had no real basis for even knowing what kinds of content would actually violate the National Security Act, and he overruled decisions by all the civil servants whose job is to know that stuff. The other thing is that Bolton separately vetted this with people who are retirees and former people in the agency whose job had been doing this kind of vetting. And they all swore out affidavits saying that there's nothing in here that violates the National Security Act. So I really can't see any basis for finding, for suspecting that when Judge Lamberth reviews the book in camera, which he is going to do now, that he would find any violations of the National Security Act, or that he would issue a prior restraint against publication, even if he did. I think the one and only legal claim in here that's real, which wouldn't stop publication, would be that if Bolton breached his contract with the government, and then he makes a lot of royalties from selling the book, he might have to disgorge his royalties and pay him up to the government as damages. But I think that's about the most that a court would possibly do in terms of ruling in favor of the Justice Department on any of their claims.
So now I'm glad that you stopped there, because money has been thrown around as an issue about this on the content side as well, especially since that might in fact be the most pertinent real legal argument, because the revelations from the book are also, I think, worth pursuing a little bit here. Now, apparently, according to the New York Times, it's kind of a boring book with just kind of moments sprinkled throughout of like, what, you know? But what Bolton argues, and this is what I wanted to kind of focus on from it, was that the House impeachment inquiry should have investigated President Trump over more than just Ukraine. As a matter of fact, concerning the Ukraine issue, Bolton offers firsthand evidence that President Trump linked his suspension of $391 million in security aid for Ukraine to his demands that Ukraine publicly announce investigation into wrongdoings by Democrats, including Biden. But he's going to argue that they needed to look into other issues. As he puts it, quote, to, in effect, give personal favors to dictators he liked, end quote. And most strongly says that, quote, he is a pattern looked like obstruction of justice as a way of life, end quote. I mean, that's some harsh criticisms. And as a result of this, though, Bolton is receiving some harsh criticism of his own. Democrats are basically arguing, look, where were you during the impeachment? Why wait until you're going to make a bunch of money on your book instead of coming forward and forcing us to make you testify? So much so that the epilogue to his book, as we can understand it, Bolton tries to preemptively shield himself from that line of attack, arguing that he wanted to wait to see if a judge would order his former deputy to testify over White House objections. Because House Democrats opted to move the case forward too quickly, it is effectively their fault. In other words, Bolton is blaming House Democrats for being in a rush. Otherwise, he would have gladly participated in impeachment hearings in a bigger way. I kind of find that I'm just going to say, I find that a little bit disgusting, his epilogue, from what I've read of the excerpts of it. What do you think about the content coming forward here? And I mean, is this just what do you think about those? Let's just start there, Ken.
Yeah. Well, of course, I haven't read the book. I did read the New York Times review of the book. And the biggest thing that jumped out at me from that review is along the lines of what you just said, is that I think one of the specific allegations is that Trump was actively inviting China to try to intervene in our election on his behalf. And he was offering them very favorable trade treatment if they would, but not if they wouldn't.
Right. And that was just one of many dictators that he's apparently, right? That was just the one specific we have so far.
Yeah. On the issue of why Bolton didn't say this earlier, I blame him, but I also do blame the House Democrats a little bit, not for rushing too fast. I don't think they rushed too fast, but I think they should have subpoenaed him. And he didn't, I think Bolton did not want to seem as though he was just running to the House Democrats out of wanting to take vengeance against Trump. But I think he did not really resist subpoenas. The subpoenas didn't come. And I don't know why. I think if the House Democrats would have subpoenaed him earlier, possibly he would have gone in there. If they just kept asking to voluntarily testify. And, I think he should have, but I also think they should have subpoenaed him. So I think there's a little blame to go around on both sides there.
Now, this is always the what if game, and you can only play so much time. Do you think Bolton's comments, had he put them into the record in the House, would have had any bearing on the ultimate outcome? In other words, do you think it could have swayed two more Republicans to have joined in the Senate?
Well, remember, you need a 2/3 vote in the Senate, so it certainly couldn't have affected the outcome, right? But I guess there'd be some rhetorical.
No, I was talking about because we needed 2 votes to get additional.
To get the subpoena.
To get additional subpoenas, and so do you think, had you had Bolton, could we have had the 2 votes not to convict, but to have continued that process because you would have had enough Republican defectors to make that move forward?
Maybe. I mean, I guess we're really specifically talking here about Murkowski, Collins. There was Romney. We needed one more, maybe. I don't know. Who would have been the one more?
I mean, that's a good question. That's why I didn't have a good answer. That's why I asked you.
I don't know. I'm going to say probably not. I don't know that there was that 51st vote to actually have a full-blown trial in the Senate, even if Bolton's revelations had come out earlier. Although, that's all we're just guessing, and I do wish that Bolton's revelations had come out earlier, because then even if there's only a 10% or 20% chance that would have led to a full-blown trial in the Senate, I would have liked to have the chance to see how that 10 or 20% chance worked out.
I can't disagree. What I will say, though, is that we're kind of running low on time. We've had a really, this has been, I think we might need to label this the Supreme Court week. I mean, that's just what happened. I'm sure you hated that.
I'm a law professor, so I'm in my wheelhouse when we're talking about this stuff.
But what we want to do is we kind of close is what we kind of do every week, which is what we've been reading. And so, Ken, you've sent us all down some pretty cool rabbit holes that generally deal with like spies and kind of cool stuff. So I'm going to let you go first, because I feel like you generally have the the cooler what you've been reading thing. So what have you been engaging with? It doesn't have to be reading, of course. What have you been engaging with?
Right. I'm gonna have to admit, after talking about the espionage books I was reading last time, I haven't yet picked up another pleasure reading book, but I will recommend. I've been watching a little television, so maybe our listeners like that. And the show that I've kind of been binge watching lately, it's I'm probably 10 years late. It's not a current show, but it's a show called Inspector Lewis, which is a British detective series. It's actually a spin-off from an earlier British detective series called Inspector Morse. It's set in Oxford, England. Every episode has very complex plots, multiple murders, and usually the professors end up being behind it all. The villains are usually professors at Oxford. So I've been enjoying watching that series quite a bit.
Oh, that's fun. The bit I went, normally I've been doing kind of what you're doing, right? Which is the more popular thing. But this week, the thing that kind of caught my eye was there was an article in Time. I'll out myself. I'm a subscriber to Apple Plus. And so I'm always kind of making the big newspaper and magazine rounds each week. And they had a piece from looking at a guy named Peter Turchin, who had actually a decade ago predicted civil unrest in the United States in 2020 based on some kind of cool mathematical models. And his paper is actually freely available in Nature, which also kind of sent me scratching my head because Nature doesn't usually do a lot of kind of social science-y research. But, in this particular case, they had. And so I'm actually going to include for listeners both the Times article that first got me interested in it, and then also the actual link to the Turchin piece in Nature itself, if you are so interested in taking a look at at least the abstract or maybe the larger take on, the patterns and cyclical nature of things like unrest and instability. I think a lot of times I find this always useful, especially for students, because I think that we often assume that whatever's happening is kind of unpredictable in the moment. But really, there's kind of institutional and structural reasons why life plays out the way it does. That's why we have social sciences. And I know why we get kind of pushed around sometimes. I think we do have something meaningful to offer. So Turchin's article on political instability in Nature. So that's what I've been doing this week. Well, anyway, Ken, it's been a lot of fun doing the show with you.
Yeah, it's been a great show.
Thank you for listening to the Politics Guys. All of the hosts, myself included, love working on the show. It truly is a labor of love. And to make it possible, it takes the support of amazing listeners like you. One of the ways you can help the show is by subscribing to the Politics Guys on the podcast app of your choice. So does sharing episodes with your friends, your family, and your other social media contacts. Word of mouth advertising is undoubtedly the best, and we certainly appreciate it each and every time you at the Politics Guys. But we also need your support. One of the great things about being a supporter, a monetary supporter, is you're going to get access to a supporters-only content. And that includes our full-length supporters-only Wednesday show. If you want to become a supporter or just want to check out more of the benefits of supporting the Politics Guys, you can check out our Patreon page at patreon.com/politicsguys. Or you can head to politicsguys.com/support. Join me and Ken again on Wednesday, leading a story about Albuquerque, New Mexico, by heading to patreon.com/politicsguys. If you've got a question, comment, correction, or just a random thought you want to share, you can reach us at mail@politicsguys.com. As a matter of fact, we'll be taking up a bunch of listener question on the Wednesday show. So if you become a supporter, you can join me and Ken again on Wednesday and listen to a bunch of individuals who sent us their comments at mail@politicsguys.com. We also strive for civil and rational debate on our newly formed Reddit at Bipartisan Politics. And we have a bunch of questions coming from there again, and I've really enjoyed the Reddit, Bipartisan Politics. We're also on Twitter at Politics Guys. The executive producers of the Politics Guys are Bruce Johnson, Wilmer Morano, Andra Masker, Daniel Toe, and Chris Wilkerson. Today's show was produced by myself, Trey Orndorff. We'll be back with a new bonus show on Wednesday. We hope you'll join us.